We've discussed in the past several days Hilchot Edut, meaning the role of how far you take a testimony from individual, the way that he presents himself, and we explained that a person cannot give a testimony for himself by himself. And here we go to real example. In those days, we have to remember the form of rabbinic courts, the Bet Din, was different than nowadays. In those days, the Betei Din has the authority to reinforce the law, meaning they not let people do whatever they wish to, but as you read, for example, in the era of Ezra, it was further on, later on, that the Batei Din reinforced the law. Amar Rabbi Zechariah ben Akatzav. We are at the Mishnah, page 27b. Amar Rabbi Zechariah ben Akatzav, Hama'on hazeh. This is a fellow who is a Kohen, Torah scholar, that lived during the era of the siege, the era of the destruction of the Second Temple in Jerusalem. So again, we have to remember the historical context. He's living at a time that the enemies, the Romans, destroyed the temple, but it was during that period that they have a forces that seize around Jerusalem. So he make an oath, and he said, Hama'on hazeh, meaning this is the house of the service of the Lord. So Rashi said that it's shvu'ai, it's a language, lashon, of an oath, and he said that this, on behalf of this house of the Lord, there are two ways to understand it: either taking a regular oath on behalf of that physical building, or more in a sense of mystical, Kabbalistic way. That's the way the Maharsha tells us in Tractate Chagiga, page 12b, that this applied to the firmament. We have in the Kabbalistic literature 7 different reki'im, and the fifth one, it's the one who reflects to the words ma'on. So anyway, he said this oath on behalf, on saying this oath, lo zaza yada mitoch yadi, meaning since Zechariah was a Kohen, so he declared that my wife's hand did not move from my hand, meaning it's not physical, it's a figurative statement that said, from I watch over her משעה שנכנסו עובדי כוכבים לירושלים ועד שיצאו. From the moment the idolaters went to seize the city of Jerusalem until the forces left, I watch over my wife every single moment. Therefore, I can testify that she was not violated. As you remember, yesterday and day before yesterday, we discussed an issue of trust in a manner of woman that was in captivity, and when she released, if she can go ahead and either leave or marry with a Kohen. So here Zechariah testified on behalf of his wife that she and him was the entire period together. However, the rabbis respond to him and said, Amru lo, ein adam me'id al atzmo. We respect you, we know that you are a truthful man, you're a man of God. However, there is a rule that applies to everyone. And the rule saying that ishto kegufo, meaning the wife considering in that sense as part of your body. And since you are nogea badavar, it's part of you, and you are total subjective, therefore we cannot accept your word in a face value. And therefore, as much as we wish to accept, but since you cannot testify for yourself, by yourself, so and you don't wish to divorce your wife, so we do not ask you to divorce her, but by the same token we cannot let you, by our laws, continue living with her in a manner of husband of wife. As we said, in those days Batei Din have much more authority, and it was their shikul dat, it was their mind or decision. And the idea is, as we explained yesterday, women that staying in captivity, the reality is that sometimes they could not pass that nisayon, that hard time, and they capture, violate them in order to be released, etc. So the Gemara said, Tana, ve'af al pichen yiched labayit b'chatziro. Even the sages told Rabbi Zechariah that he cannot any longer live with his wife. He allow her, they allow him to live, since he allocate for her in his yard a house, so they allow them to do that and not ask him to divorce her. The Me'iris said that they have children together, etc. וכשהיא יוצאה בראש בניה, וכשהיא נכנסת בסוף בניה. So when she will go out of the courtyard, she will go out before her sons, so that she will not be alone in a courtyard with Zechariah, with her husband. And when she will enter the house, she will enter after her sons for the same reason. So they are very careful not to enter the domain of Yichud, because the manner of Biha, the cohabitation, it's prohibited to him. So therefore Abaye presents a quandary, Ba'e Abaye, Ma'u la'asod bigrusha ken. So Rashi tells us, Kohen, last line, Kohen shegiresh et ishto, Ma'u ladur imo b'chatzer. If there is a Kohen who divorced his wife, is she allowed, if for example he have a large yard, he allowed to have her, his divorcee, live by the same domain, just a different house in his yard. Hatamhu de bishvuya heikelu. You said that when it's come to a capture, you have only a concern that maybe the idolater violated her, so maybe nothing happened. So therefore, aval hachalo. But here, when it's come to a divorcee of Kohen, the rabbi is not lenient. Why? Because the Torah tells us in Leviticus chapter 27 that the Kohen, by the biblical law, is prohibited to the divorcee. So therefore, they should not be attached to each other after they get divorced. Or Dilma Loshna, or you may say perhaps the case of a divorcee is no different, and therefore it's okay for her to live at the same domain, just a different house, in his yard, for example. Tashma, Detanya, we learn in a Braita, Hamgaresh et ishto, lo tinase bishchunato. When a person divorced his wife, so she should not live in his courtyard. Rashi tells us the reason for that, it's because לפי שמכירה ברמיזותיו וקריצותיו שמא יבואו לידי עבירה, meaning since they divorced and she and him have a certain code, such as Rashi said, winking, hinting, etc., and the concern they go back and have a manner of cohabitation. So therefore, of the intimacy the one shared, her living there will lead to transgression. 28, ואם היה כהן לא תגור עמו במבוי. So here you have a disputation between Rashi and Tosfot. The idea is that Kohen is prohibited, as we said, with a divorcee. So therefore, they should not live even in an alleyway, the same location, because as we said, when it's a regular Israel, so he can have her back if she did not marry anyone else, versus the Kohen cannot. So therefore, Tosfot said they have to have a distance of Gimel Batim, of 3 houses. Rashi, as we said that there is the issue of winking, hinting, etc. But the way that they presented here is that Lo tadur imo, she will not live with him in the same alleyway. So it means all those courtyard, even 10, because as Tosfot said, when it's come to a relationship between Grusha and Kohen, divorcee and Kohen, it's in a sense more lenient. But there are many Rishonim, early rabbis, that disputed Tosfot and said a total other way. And they said when it's come to a married wife, they are more stringent, and therefore they should not live at the same neighborhood, versus Kohen and divorcee, it's in their view much lenient, and it's enough to have an alleyway. But אם היה כפר קטן, זה היה מעשה ואמרו, כפר קטן נידון כשכונה. This situation happened in a small village, and they said you treated as a close neighborhood. So again, the idea is she should not live close to her ex-husband. So as we said, that it's a disputation between the early sages, Rosh and Ran versus Tosfot, and it's way more to discuss. In general, is how far distance they should go, and how different is the Kohen and divorcee versus a regular case of Israel and divorcee. So the Gemara asks, Mi nidche mipnei mi? Who is outside in favor to whom? Meaning, which one we require to have leave? Is he needs to leave the house, or she needs to move out? Tashma de Tanya. He nidchet mipanav, ve'enhu nidche mipanea. One writer said that she is outside in favor of him and leaves, and he is not outside in favor of her. However, v'mayta chatzer shela, but if the courtyard was her, so meaning they live in the house that belonged to her, therefore, by force of circumstance, hu nidche mipanea, he needs to leave, which means he is outside in a favor of her. Ibaya lehu. So the rabbi is asking a question. In that case, so if you have a situation that hayta chatzer shel shnehem mahu, imagine a situation that each of them have a house, they share a courtyard, they have a house, individual house, the same courtyard. How you treat it? So, who needs to leave? He needs to leave because of her, she needs to leave because of him. I cannot tell you how many times while I used to do counseling, I heard people saying, you know, we live in the same house, but we have a different room, and we don't have an interaction and sometimes not even talk to each other for a long time, etc. Very sad, but that's the reality. So here they ask what to do. תשמע, היא נדחית מפניו במאי עסקינן, אילמה בחצר שלו פשיטה. If it's in his yard, it's obvious. ואלה בחצר שלה, והתניא אם הייתה חצר שלה, הוא נדחה מפניה. אלא לאו כי היי גבנה. You have to speak about the courtyard that belonged to both of them, and therefore, because of this conflict, she needs to leave. Dilma de agir meigar, meaning how about if both of them have a lease in that courtyard, meaning the houses it's not belong to them, meaning if they owns the houses, so you cannot say that she leave because him, because you mean to say that you have to enforce her to sell her house and buy another one. And in those days it wasn't any manner of women doing this type of business with selling properties. So therefore we should ask the husband to leave, versus if both of them are renting. That's the way Shita Mekubetzet puts it. But they said, Mai Havei Allah. So what is the conclusion in that way? Tashma. So here bring you a line, a pasuk. Isaiah used it for a different connotation, but use it here for the purpose of explanation. So this is in Isaiah chapter 22, verse 17. הנה השם מטלטלך, טלטלה גבר. The Lord will dislocate you, the dislocation of a man. So what does that mean? Part of Isaiah curses or warning, as the Radak said, is telling the people that you're going to move and shake from different locations. It's act of the punishment. So we derive from that, Rav, why they use the male in the terminology. They use taltela gever or gaver, which means the man. Talteluya de gafrin, de gavra kashin meiteta, which means the dislocation of a man is more difficult for him than dislocation for a woman for her. So the idea is, the rabbi said that in a sense he is, especially in those days, he is responsible for all the arrangement, and it's a huge undertaking. That's one of the avenue. But anyway, since in the hair case it's usually people who are taking care of all the things involved with the moving, therefore she has to move and not him. But here is another din that the Rambam said that that's apply also to a regular divorcee of Israel. Not everyone agreed, but anyway, in general we understand it's applied to Kohen. But as we said, not everyone goes along with that idea. Tanu Rabbanan, lava hemena benichsei avia. You have a fellow Kohen who married a woman who was wealthy. So he borrowed money from her, that part of the collateral or part of the property is something that she inherited or received from her father, and it's her. So therefore, when it's now a conflict and he needs to pay her, אינה נפרט אלא על ידי אחר. In order for her to receive the amount of money he owed her, the Gemara said that she needs to use a Bet Din emissary to collect the fund, but they should not meet each other. Why is that? The concern is that we learned in the past the difference between Nichsei Tzon Barzel and Nichsei Milog. And we explained that certain property, no matter what, You don't need to have prenuptial agreement. It's just part of the deal that it's her no matter what. So therefore, in a case of situation like that, it may happen for several reasons. Either because of their past relationship, or because he maybe want to ease up the payment. So it may happen that they will go back to have sexual relation when it's come to that monetary payment. And the way that in general we paint the issue is that since the Kohen is prohibited to his divorcee, we required to have a shaliach, to have an emissary in between to take part of all of this final stage of transaction of returning the money that belongs to her. The same apply to other properties. Now, remember in the framework that in those days the rabbinic court have the power to reinforce. So in general, the idea is that she is not allowed to collect that money independently, but she needs to go before the court, to have the court appointed an emissary to do it for her, someone that the court trusts, etc. The Tur in Even Ezer 119 said it's also go the other way around, but they use the term of borrowing from nichsei milog, those property that he basically takes and use during the time of marriage, because that's the most common, because usually the Shita Mekubetzet said at the time of the divorce he paid as part of the process before getting the final stage of the get, he paid her the amount he commit himself in the get. So therefore, the rest of the issues that left, they need to have that intermediary. Amar Rav Sheshet ve'i atu lekaman ledina. If this Kohen and his divorcee come to us directly, which means we have a date, a time of a court session, the three rabbis, judges, dayanim, sitting in a court, and they appear without having any emissary. And as we said, we differentiate between Kohen and Israel, but for our understanding so far it's a Kohen. Lo mizdakekinan lo. So we are not let them come before the court and have the session. Why? Because we do not accept them together because of the issue of Kohen and divorcee. Rav Papa amar shamutei meshamtinan lehu. If they do that, they are in violation, and we should put them under the cherem, which means that we discommunicate with them. In those days, again, it was very different. Someone who was under that ban, the people not allowed to communicate, meaning to eat, to drink, etc., and to be together with that fellow. Rav Huna Breder Rav Yoshua Amar Nagudei Name Menagdinan Lehu. He said that we also give them malkot. And again, it was said in addition to Shamutei. Amar Rav Nachman Tana Be'evel Rabati. That's a tractate smachot. That's one of the small smachot, small tractates that dealing mainly with the law of mourning, burial, etc. So they call it smachot because it starts with the line Hagoses, one who's in the breath of death, Hareu Kechai, we treat it as a living. Anyway, Bamei Dvarim Amurim, when the divorcee of Kohen, she allowed to claim for her divorcee to use someone in between, someone is an intermediary, Shenitgarsha Min HaNisuim, when where she was divorced from marriage. אבל כשנתגרשה מן האירוסין, נפרט על ידי עצמה. When she divorced from the betrothed, and we explained several times that that's a different stage in those days, so therefore שאין ליבו גס בה, because she have a different, it's not accustomed to her, it's not in that type of relationship, so he will not, we don't have a concern that they may cohabitate. As we said, that in those days they differentiate between the act of betrothal and the act of marriage. Here is the story. Hahu arus va'arusato de'atu lekamei derava. Here you have a pair, a couple that not married yet, is a Kohen, and he's engaging, that they divorced after they betrothed, and they came by themselves before Rava court with the monetary conflict between the two. Yativ Ravada b'matna kamei. This is one of the rabbis said there. Okay, Rava shlucha bentayu. So Rava right away appointed someone to be in between them. Amar le Ravada bar matna b'amar Rav Nachman tana be'evel rabati. Amar le kachazina lekagaise ba'adad. I already look at them and I see that there is some chemicals or some intimacy between them. So meaning even they divorce from the time of the betrothal, I see that the way that they hint to each other, wink to each other, they're not embarrassing from each other, the rabbi said. So I already see that they may enter to cohabitation, therefore I would appointed someone to be in between. Ika de Amrei, lo okei Rava shtaliach benatayu. He didn't appoint someone. Amar le Ravada bar matna neikum ar shlucha benatayu. The other suggested that. Amar le v'amar Rav Nachman tana be'avel rabati. Amar le anamira echad elogay seba'adai lo ve'ak chazin legay seba'adai. So again, you have to differentiate when you see the judge and Dayan Dan. The judge only according to the way that he recognized. And here, if they see that they are accustomed to each other, so we have to have a separation. Now we go to the Mishnah, dealing with credibility of witnesses. So since the previous Mishnah mentioned a situation where the sages use a disqualified witnesses, here we see other rare cases that you go that direction. Ve'elu ne'emanin leha'id begodlan, which means ma shira'u bekotnan. Someone saw something and he was a minor. Now he passed the age and he is already in the age of adulthood. So part of the Eidut Kshera, to consider someone as a qualified witness, he needs to be during the time that the incident happened in all the qualification. Now here you have a case of someone who is accepted, who is credible, even the incidents that he was involved or he saw was before the time that he was qualified. נאמר אדם לומר, זה כתב ידו של אבא. A fellow can say he is now mature, he can testify over documentation, saying that he see his brother or his father signature on the document, and he recognize that as their signature. It's not, doesn't mean that the son can enforce his father for something, even if he was reached the age of maturity, is the recognition. זה כתב ידו של רבי. This is my teacher's handwriting. וזה כתב ידו של אחי. And this is my brother's handwriting. Meaning, even he never saw the handwriting after reaching the majority. So the Rashi said even they are no longer among the living, it's accepted. זכו הייתי בפלונית שיצאה בהינומה וראשה פרוע. In those days, as we said several times, that those who are virgin, meaning the first time they married, between their leaving their home to the time of the chuppah, they have this hinuma, and they have the open hair on their shoulder. That's, if you remember, we studied on page 15. So that's one of the proof that we can require the man to pay the Ketubah 200 zuz, because that's the Ketubah betula. ושהיה איש פלוני יוצא מבית הספר לטבול לאכול בתרומה. And also a testimony that I saw certain individual left school to immerse in order to partake the truma. ושהיה חולק עמנו על הגורן, and he will be part of us in the threshing floor, so he's a kohen. והמקום הזה בית הפרס, this field there is a grave that was plowed, which is you see a bond all over, and therefore you have this safek, you have the uncertainty of tum'ah, of ritual impurity. ועד כאן היינו באים בשבת. This is the border that we attend, that we come on Shabbat. So this is basically the Shabbat boundary. אבל אין אדם נאמן לומר, but a person is not credible to say, דרך היה לפלוני במקום הזה, this so and so at the path in this place, מעמד ומספד היה לפלוני במקום הזה, it was a place of standing and sitting and deliver a eulogy in that place, so meaning that place belonged to a certain person. In those days, they used to have a eulogy in one location, and while they carries to burial, they stop to do a 7-time ma'amadot. So in that sense, it's expression of right in those days. So since in all these testimony involved with a monetary payment, you cannot count on a person who saw something when they are in their age of minority, but you need to have some 2 witnesses that were mature at the time of the incidents. אמר רב יהונה ברי דרב יהושע, והוא שיש גדול עמו. Even you speak about someone who talk about what? The age that he was a minor, you have to have someone who is in the age of maturity at that time. So if you talk about women that married when she was a betula, so you can depend. But the others, so I meant not depend. You need to have another mature ed to approve it. Versus when you talk about Truma, you talk about Beit HaPras or the Shabbat boundaries, that's enough with one witness. You don't need the other one. That's the way the Rosh and Ra'ived said. Utzricha. Why you need all these 3? The father, the teacher, the brother. The I ashmi'inan aviv. If you talk about the proof in the Mishnah that speaks about the father that he saw when he was young, you said mishum de shchiach gabei, because he is a lot with his father, so he recognized his handwriting. Aval rabo lo, but maybe his teacher not. So therefore, the Mishnah tells us that he is trustworthy, loyal, even in regard to handwriting of his teacher. V'yashminan rabo mishum de itlei emtei de rabei. In those days, they have the awe, the reverence of the teacher. So the student remember all the details. Aval aviv lo, but the father not. So the Mishnah tells us that it's also credible. And these two, אביו דשכיח גבי, רבו דהתלהמתה, אבל אחיו דלת ללואה ולואה, but his brother, he doesn't have neither the frequency nor the reverence, אימה לו כמש מלאן. So therefore the Mishnah needs to tell us only the third situation, which is his brother, the כיוון דקיום שטרות מדרבנן. So since the whole idea of validity, ratification of document is required by rabbinic law, so as the Torah law, the signatories are sufficient proof of a document validity, Hemnu Rabbanan Biderabanan. The sages deem him credible to testify in cases that he witnessed as a minor in matters that are by rabbinic law, including the case of his brother. Now, it's a disputation between Rashi and others how you differentiate between דאורייתא and רבנן here. זכור הייתי בפלונית שיצאה בהינומה וראשה פרוע. So here the Mishnah speaks about a fellow that he said, I remember the wedding of so and so, that she went with hinuma, as we explained, with the open hair, it was uncovered, so, and therefore she deserved to get 200 zuz. My ta'ama, why the sages count on that as a proof to collect money, and how you count on a person that said that when he was in the age of being a minor. So he said, כיוון דרוב נשים בתולות נישאות, גילוי מילתא בעלמא הוא. So I explained in my book, the Rashi said, גילוי מילתא בעלמא הוא, כלומר אין הדבר צריך עדות, אלא לפרסם שיצא הדין לאור בלא גמגום. According to the Mishnah, we understand that someone who reached maturity, gadol, he can testify over something that he saw when he was a minor. So therefore we accept it. The question is why he is credible. So we bring a proof, for example, of that one that she came out while the hair was open, etc. And she can collect the 200 zuz by having that testimony. So if you remember on page 16b we have a Tosfot that said that since, especially in those days, most of the women married when they are virgin, so therefore we go by the ruba, by the way that most of them. But here we don't go just by the ruba, and he said gilui milta be'almahu, which means that that it's something that it's known. Since, as we said, that most of the women married while they are virgin in those days, you can go by the majority to say that, all right, if that's the case, he needs to pay her 200 zuz, but because you go by the concept of majority, so you do not need this act of testimony to prove anything. The only is that is in a way of Rashi is like reaffirmation of the ruling. So therefore the rabbis are more lenient that we depend upon this testimony. Yes, there is Gemara in Bava Batra 92b that dealing with the concept that when it's come to collect money you need to have this rov, the majority, but anyway, שהיה איש פלוני יוצא מבית הספר לטבול לאכול בתרומה. So here it's a testimony that Mr. So-and-so leaves school to immerse in order to partake the truma, and therefore this is like a proof that he is a kohen and he allowed to partake the truma. So the Mar challenged that how this is a real proof. V'dilma eved kohenhu. Maybe it's a servant of a kohen who is also eligible to partake the truma, and therefore he ate the truma because of his master who is a Kohen, and it's not a proof. מסייע לרבי יהושע בן לוי, ואמר רבי יהושע בן לוי, אסור לאדם שלמד את עבדו תורה. He hold that a person cannot teach his slave Torah. So the testimony it was, he was in school, so it's not a slave. So the fact that he partook the truma, they say that he is a Kohen. So Gemara challenged that. The Shita Mekubetzet said that this question is only for the siyua, not the key point. Now, velo, is that true that the person cannot teach his slave Torah? Ve'atanya lava emenu rabo. Usually, the master did not borrow money from his servant, but he taken anything from his servant, not with the mindset to return. Why? Because the Meiri tells us, based on Gemara in Gittin, page 40, that whatever the slave acquires is part of the property of the master. So it means that this is not a proof that this servant is going free. But here they said, Lava emenu rabo, if the master borrow money from his servant, or she'asa'o rabo, or in a case that master made him 28b, apotropos, meaning he made him as a representative for his property to purchase or sell. So the Gemara in Gittin, as we said in page 40, said that usually master not does that with his servant. So therefore it's kind of odd, it's rare. Or sheiniach tefillin bifnei rabo. Mitzvot that depend graman, that depend upon the time, not apply to a slave. For example, sukkah, for example, lulav. So tefillin is also, in some view, it's depend upon time, because at night we don't put tefillin. So based on several sources, the slave not put tefillin. But if he does that, and the master did not reject that, it's a proof that he is not a slave. או שקרא 3 פסוקים בבית הכנסת, which means that he read 3 psukim, that it shows that he is a free man, because it's not in the respect of the public to have a slave reading the Torah. More on that, it's the Orach Chaim Reish Pei Bet 282 at the Ramah. The Avet said that that's not proof, because the reality is that the slave can involve with Torah, because otherwise why you mentioned that, and why Rabbi Shimon Levi disputed it. So the Gemara said, Hatam de ikrei eved mida'ato, ki amrina ka'amrinan de kanahig ben minhag banim. Sometimes the relationship was so deep and so good, so he treated him like a son. So he teach him Torah, he put him in a school with his children, etc. The whole idea the Ran explained is that because we don't want people to conceptualize him as a free person, but it's not because of prohibition to teach him. So anyway, the Mishnah said, Litbol le'echol bitruma. You saw him leaving the school to duck himself for eating the truma. So they speak about what? Bitruma de Rabbanan. That the sages permitted only in partake of truma by rabbinic law. V'shaya cholek imo al hagoren, that he was share the truma with us in a threshing floor, and therefore is a kohen. V'dilma eved kohen hu, and therefore he eat it because of his master, which means, as the Tosefta said in Yevamot, page 12, that if you have a child that came out of wife of Kohen that mixed with of the child of the servant, and in those days you do not recognize them, and now each of them have a chance to be Kohen, have a chance to be a child of a slave. So therefore you treated them differently. So how you prove that he is a Kohen? תנן כמאן דאמר, אין חולקים תרומה לעבד אלא אם כן רבו עמו. דתניא, אין חולקים תרומה לעבד אלא אם כן רבו עמו. דברי רבי יהודה, רבי יוסי אומר, יכולו שיאמר הם כהן הניתנו לי בשביל עצמי, והם עבד כהן הניתנו לי בשביל רבי. So it's kind of disputation, because according to Rabbi Yehuda, you give him only when his master with him. According to Rabbi Yossi, he can say, look, you have a predicament, since you have a option that I'm maybe a Kohen, as a Kohen servant, give me for my master. And if I'm a Kohen, give me because of myself. So either way, you should give me. So therefore, the Mishnah follow Rabbi Yehuda, and therefore, the fact that we have a witness that they gave from the threshold, the Truma, they show clearly, unequivocally, that he's not a slave, and most probably he himself is a Kohen. במקומו של רבי יהודה היו מעלים מתרומה ליוחסין. In the place of Rabbi Yehuda, they will elevate one who eats truma to their presumptive status of kehuna, of priesthood, for the purpose of lineage. So you see that you can give a truma to those slave of a priest only if his master is present. That otherwise he will be elevated to priesthood. במקומו של רבי יוסי לא היו מעלים מתרומה ליוחסין. So therefore Rabbi Yossi was not concerned to give a truma to a servant of Kohen that come by himself, because he's not concerned that any michshol, that any stumbling block will come out of that. The Tosfot, in the previous part, in Amud Aleph, explain why we're not concerned about the slave receiving truma even after his release. The Shita Mekubetzet also explain. Anyway, Tanya Amar Rabbi Lazar Rabbi Yossi. He gave a testimony. The truth is, Gemara in Yevamot 99, this story was brought to someone else, Rabbi Lazar bar Tzadok, or according to Yerushalmi, Rabbi Ishmael bar Rabbi Yossi. Anyway, Miyamai lo e'adeti, I never gave a testimony in the testified in rabbinic court. פעם אחת העדתי והעלו עבד לכהונה על פי. It was one time I gave a testimony over a person that partake truma at that threshold, and they elevated a slave by my word to a priesthood. So they said, hey, Lusal Kadatach, you mean to say just by his testimony they elevate him? השתא ומה בהמתן של צדיקים מן הקדוש ברוך הוא מביא את הקלה על ידם. This is a famous story in Tractate Chulin, page 7, about the donkey of Rabbi Pinchas ben Yair. It's a story that they brought before the donkey a barley that was made out of demai. Demai meaning damai. You are not sure if it's tightened or not. So they brought it before his donkey, and it's in that sense, for our understanding, the donkey was a righteous one, right? For animal lovers, will be easy to understand. So therefore the donkey refused to eat it. So they said that the stumbling block was not come upon those in that level, tzadikim atzmam, lo kol sheken, how much so applies to righteous people themselves. Ela, you have to say, ביקשו לעלות אבל לכהונה על פי, so they wanted to elevate a servant to priesthood by my word, but then the truth came out and they did not elevate him. How? Chaza, Rabbi Lazar saw that they dispersed to that individual a turn at the end that he is a slave from the truma in the threshing hall. Be'atrei de Rabbi Yossi, the place that they used to do it, in the place that Rabbi Yossi lives, that they used to give a truma to a slave, even his master wasn't there with him. Ve'azal be'ashed be'atrei de Rabbi Yehuda, and here he went and he testified about what he saw in the place of Rabbi Yehuda, where one elevates from Truma to priesthood. So here is a serious issue, but again, it was different location. שהמקום הזה בית הפרס הוא, that place is a בית הפרס. So they said, my tama, why we take it in those places, a limitation of beit הפרס, said because it's rabbinic, beit הפרס the Rabbanan. So the sages are the one who put a decree for a corpse, ritual impurity, a place that was ploughed, and they have a grave there because they concern that it may be the bone will disperse all over in the level of seora, even a small level of very small, tiny around the field. So biblically speaking is fine, but rabbinic is the issue. So therefore the same sages allow to purify that field because of that testimony that witness remember from his age of minority. Amar Rav Yehuda Amar Shmuel, he said, in order to receive, involved with a paschal lamb, so a person needs to check the beit הפרס, when need to pass by that, מנפח אדם בית הפרס והולך. So this is something that we learned already in the past, but the idea is a person who passes through the beit הפרס may blow on the dust before taking each step, so that there is if is a bone beneath the dust that he will expose, avoid it. Then they said, והולך, אני process. רבי יהודה בר עמי משמע לרבי יהודה אמר, בית הפרס שנידש טהור, מה היא טעמה? אי אפשר לעצם כסעורה שלא נידש ברגל. You not have a bean trodden underfoot and rendered smaller. So this presumption is possible only in cases of impurity by rabbinic law. ועד כאן היו באים בשבת כסבר תחומים דרבנן. He hold that the Shabbat boundaries is rabbinic law, and the sages deem it incredible in matter of rabbinic law. ואין נאמן לומר דרך היה לפלוני במקום הזה, מעמד ומספד היה לפלוני במקום הזה, מה היא טעמה? הפוקי ממונה לא מפקינן. That the reason is that we do not remove money from the possession of its presumptive owner on the basis of testimony about a matter that he witnessed as a minor. תנו רבנן, נאמן התינוק לומר כך אמר לי אבא, משפחה זאת טהורה, משפחה זאת טמאה. So the sages said the child deemed credible to say when he reaches majority that this is what my father told me when I was a minor. This family is pure, this family is impure. So they said טהורה וטמאה סלקא דעתך. You mean to say that he can testimony over purity and impurity, אלא משפחה זו כשרה ומשפחה זו פסולה. To say that this family is befitting or not. Now, the whole idea of the Rambam tells us in Ilchot Edut, chapter 14, that here we're dealing with a lineage of a family of priesthood, and it's basically allow them to eat truma or to prohibit them. The Ran said that when you have a witness that testified over something he saw in his youth, he cannot discredit or put a pgam in the lineage of a family that we hold that they are fine, or vice versa. So the Ran explained the Rambam, this is specifically in a family of priesthood that we knew there is an issue there. So it's not the entire family, it's part of the family, and he testified, this minor, over the part that it's not, that is pasul. He just clarified, but again, it's more on that on the Ravid. ושאכלנו בקצצה של בת פלוני, I see running out of time, ושואלים הולכים חלה ומתנות לפלוני הכהן, על ידי עצמו, אבל לא על ידי אחר, וכולן, אם עובד כוכבים ונתגייר, אבן להשתחרר, אין נאמנים. ואין נאמן לומר דרך לפלוני במקום הזה, מערנו מספד על פלוני במקום הזה. רבי יוחנן בן ברוקה אומר נאמנים. רבי יוחנן בן ברוקה, היה, what exactly dispute, אילמה סעיף אפוקלומונה, אלא הרישה, בכולם היה עובד כוכב ונתגר ונשתחרר, הם נאמנים. רבי יוחנן בן דורק היה אומר נאמנים. במייקה מפליגי, what's the source of the disputation? תנא קמא סבר עד עובד כוכבים הוא, דלא היה ודייק, he's not very careful of the detail of the story. ורבי יוחנן בן ברוקה סבר כמאן דעתי איגיירי מידקה ודייק, because he intend to convert, so he is very careful. So now, my קצצה, the last part is dealing with what's the meaning of קצצה. בתנו רבנן, כיצד קצצה, אחד מן האחים שנשא אישה שאינה הוגנת. לא, one of the brothers married to someone who's not befitting for him. באים בני המשפחה מביאים חבית מלאה פירות ושפורים אותם באמצע רחבה. The family members come and they bring a big barrel full of produce and they break it at the city. ואומרים, אחינו בני ישראל בית ישראל שימו. Our brother, the house of Israel, listen. אחינו פלוני נשא אישה שאינה הוגנת לו. Our brother married someone, it's not befitting to him. ומתארים אנו שמה יתערב זרעו בזרענו. And we are concerned that maybe our descendants will be mixed with ours. בואו קחו לכם דוגמה. Come and take a sign, which means to take some produce. And this is to remember, Rashi said, that it will be some remembrance for the future generation. The Parasha said since the children like produce, so that's the reason. Anyway, they said, בואו קחו לכם דוגמה לדורות שלא יתערב זרעו בזרענו, that his descendants will not intermingle with our descendants. So the gathering of the large crowd to take the fruit generate publicity. וזוהי קצצה, and that's the meaning of קצצה, that the child will witness, שהתינוק נעמד להעיד עליה. So therefore, someone who's past the age of minority, he's now an mature adult, is deemed credible to testify about it when he is an adult, and it's all related to the Pgam Yuchasim. So here the Ran explained, it's family of Kehuna, priesthood, that we heard that there is the issue of psilut, that they are not qualified, and therefore this ktatza clarified that it's only in one house and it's not in everyone. It's not bring any chidush, but it's just clarified what we already know. So therefore, it's just paved the way for other brothers to eat truma by rabbinic and nothing more than that. But the Ravad for sure elaborate on that a lot, and it's welcome to read both in Ravad and the Rambam. Adran alach ha'isha shenit'armela.
Boyachem leshuloim malachai yeshuloim malachai